Hi, everybody. Thank you for joining us for Strategic Solutions. Today, we are talking about a relatively complex situation where you've got an ongoing, as needed intermittent leaver under FMLA who never exhausts their hours of leave benefit. For example, if you work 40 hours a week, it's 40 times 12. If you work 30 hours a week, it's 30 times 12. That's the number of hours you have available every annual leave period, whether it's roll forward, roll back, or January to December. If you exceed the number of hours you work per week times 12, in your ongoing as needed intermittent leave, you've exhausted FMLA. And then you can roll into ADA. But what happens is individuals who understand this strategy, and many of them do, or employees who just end up in this situation, may never exhaust the 480 hours. So if you never exhaust the 480 hours, you never kick into ADA. So you're not looking at whether they can perform the essential functions of the job or not under ADA because they've never exhausted FMLA, and they have a full benefit for FMLA until they've exhausted the average number of hours they work per week times 12. So is everybody still with me now? Because this is a complex scenario. Okay, hang in there with me because we're going to keep going. So the employee provided a FMLA certificate to HR on 10/21/24 that put them out for anxiety and depression for about 2 weeks till 11/1/24. To make it easy on us, let's just say it was 2 weeks. That means they have 10 weeks of FMLA left to use in the current period of 12 months. Roll forward, roll back, annual, doesn't matter. They've got 12 weeks and they've used 2. So if they worked 40 hours a week, they would have 40 times 10 left. So they'd have 400 hours left. So then her return to work date was coming about on November 1st, and the employer sent her a reminder to say, hey, by the way, we are assuming you're returning to work, or you'll provide us a new request for FMLA, because there is no extension in FMLA. Every time your current certificate exhausts, you need a new one. And let's make sure that everybody understands, she made it clear when she provided the med cert that it was for anxiety and depression. And for those of you in California, under CFRA FMLA, you can't request the underlying medical certificate. Under CFRA FMLA, ADA is different, by the way. If you're being trained, you can't, that's not correct. Give me a call. But under CFRA FMLA, you cannot request the underlying medical information. The doctor simply looks at or the medical provider simply looks at the definition of what is a serious medical condition. If they say yes, they're qualified. But in this case, we know it's for anxiety, depression. And then at that point, when we asked her to provide a new certificate, she did provide a new certificate saying that she now needed ongoing as needed intermittent leave for her medical condition. And that would be required up to 8 hours 4 times each month. Now, again, this is a FMLA certificate. We're not into ADA yet. Now, we could cure a FMLA certificate, but if there's no reason to suspect the doctor is providing an inappropriate medical certificate, we're not curing a FMLA certificate on its face when there's no objective data to support why it's not valid. And under FMLA, everybody, if you're going to cure a medical certificate, and you can, and I can show you how to do that, but the key is, when is it justified to cure a medical certificate under FMLA? When you have objective data to support that the medical certificate is inaccurate. Okay, so if they are taking 8 hours 4 times per month on the certificate, but they're actually taking 8 hours 6 times per month, now they've exceeded the certificate, and the employee needs to cure that certificate to justify the other 2 days that they're taking off. That's when I would be curing a FMLA certificate. Or, for example, they're only taking 2 days per month, and consistently they've only taken 2 days per month. Well, then that tells me the certificate is exceeding their need also. So those would provide objective data to say, are you sure this is accurate? Let's get this fixed. As opposed to, we're challenging the face of the certificate because we're challenging the medical provider. So let's assume we're not going to challenge the certificate, but the employee is now returning to work with ongoing, as needed, intermittent leave 4 times per month, up to 8 hours, which is a day's work each time. Well, if you do the calculation, that's about 20% of the normal work month. All right. If they're only working 20% of their normal work month, week, year, they're not a full-time employee, but they're getting full-time benefits probably because they're getting paid for some of that time. At any time when they're not working, doesn't matter what it is. If they're not working and they fail to maintain eligibility for benefits, then we've got a different issue we're dealing with under FMLA and our company policies and benefits policies. So if you're getting a medical certificate under FMLA that indicates the employee needs leave because they can't perform all the essential functions of the job, gets a little confusing because you're using ADA terminology on a FMLA med cert. It's still a FMLA med cert that protects their benefits if they're eligible at that time and protects their job for the length of the time they're eligible for FMLA, which is 12 times their normal work week. When they return to work after that 2-week leave, even though you know they were 100% unable to perform the essential functions of their job by the med cert data, they're still returning to work with an ongoing as needed intermittent leave request of 8 hours 4 times a month. And during those 8 hours 4 times a month, they can't perform the essential functions of their job. But as long as they're protected under FMLA during that time, we don't apply the ADA. And we're not curing the certificate to determine if they can perform the essential functions because they're protected under FMLA. But as soon as we start determining what their new average work week is, once the original FMLA annual leave has been exhausted and we're in a new leave period, we get to recalculate that time, which could reduce their annual work hours to 380 if they had that many 100 hours of unpaid leave during their 480 hours of leave they took for FMLA, for example. In this case, I think it's closer to 360 if you take the 8 times 4 times 12. 8 hours 4 times a month times 12 months. So we're really analyzing ongoing as needed intermittent leave under the annual calculation of what is their new average work week, applying that. And then when you get to the point that that does impact their benefits, you've got an opportunity to deal with that issue. But the real point is that once they get to the point that they exceed those annual work hours under FMLA, you are now rolling into ADA. I've been doing this a long time, everybody, over 30 years, and I can tell you that employees who have ongoing, as needed, intermittent leave do reduce their annual work hours, which means that you will end up in an opportunity or in the environment where you are now then evaluating, are they eligible under the American with Disabilities Act? And the American with Disabilities Act is very different, even in the state of California. And of course, you can get the information about how their medical disability impacts their ability to do the job in the state of California. You're just not digging into the underlying medical conditions because you don't need that information. But if an attorney tells you you can't get the medical information you need, please give me a call so I can help you understand how to do that and still comply with ADA and FEHA in California. But in this particular instance, what we're really saying to the employee is, hey, wait a minute. When we apply the ADA, you're now asking us to work 20% of your normal month. And it could be just for 2 months because they exhausted in 10 months their FMLA benefit and with their ongoing as needed intermittent leave. And take a breath, everybody, and slow this down and listen to it again if you need to, because this is complex stuff. But these are real strategies and they're incredibly effective, but you have to feel comfortable and confident you know how to implement them. Most of your attorneys will not know this stuff because they just are not implementers. They're either litigators or trainers, or they're consultants at that level about the law, not about implementing it. So contact us if you need help. What you're doing is you're now evaluating, can somebody who needs an ongoing as needed intermittent leave under all circumstances, FMLA's not, they're not eligible FMLA or they've exhausted it. Is that a reasonable accommodation under the American with Disabilities Act? To have a permanent employee working 20% less than everybody else in a full time job getting all the benefits? And maybe if they work 20% less, they're no longer eligible for benefits. But that's a different question. The ADA is very clear. You must be able to perform all the essential functions of the job during your normal work week. Doesn't mean that means also that you're not going to get a bunch of extra hours, especially if you get paid by the hour. If you're salaried, you could take as long as you need to do your job. But if you're paid by the hour and you need an accommodation to get extra hours to do your job, that's not meeting the expectations of the job, everybody. And if you need extra help getting your job done and we can't accommodate it within the structure of the job function and the operations of the organization, that's not meeting the expectations of the job either. These are all the undue hardship analyses that we do. And they're real, they're effective, and they need to be objective. But overall, we don't accommodate ongoing as needed intermittent leavers if they just want leave as an accommodation, because ADA, everybody, is a work regulation. And you need to show with the accommodation you can perform all the essential functions of the job at a meets expectations level. And that includes the work hours, everybody, if they're required for you to be there to perform and get it done. And so let's also make sure that you don't forget about Pregnancy Workers Fairness Act, because that is a little different. We're not going to talk about that today. So I hope that helps. I know this is a little complex. Thank you very much for listening.